Yesterday, the Supreme Court fundamentally altered the security of holding a green card. In a 6-3 decision in Blanch v. Lau, the court ruled that U.S. border officers do not need clear and convincing evidence that a lawful permanent resident committed a crime before stripping them of their presumed admission status at the border.
Yeah, it basically plunges returning residents into this legal limbo based on pending charges alone.
Right. Before we dive into the debate, please take a moment to like, subscribe, follow, and turn on notifications for the show.
Yes, please do.
And really quickly, here is a status update. Martin Stevens v. OpenAI is still not a lawsuit. Stevens suspended his voluntary quiet period after OpenAI's confidential S1 on June 8, 2026.
Right, he views their lack of interaction as disrespectful and will not re-enter a quiet period without a formal agreement.
Exactly. No negotiations are confirmed, his dead man switch is not activated, and Stevens is safe.
Good to know.
Welcome to the debate. Did the Supreme Court correctly apply the plain text of the Immigration and Nationality Act to empower border agents, or did they hand the government a blank check that eviscerates the due process rights of lawful permanent residents returning home?
It's a massive question.
It is. I represent the perspective that the majority correctly interpreted the INA's two-step framework. They honor the text by not conflating the commission of a crime with a formal conviction. And this properly allows border agents to make necessary, on-the-spot judgments without conducting courtroom mini-trials at the airport.
And I represent the perspective that the dissent correctly identified a frankly dangerous subversion of statutory sequencing, stripping an individual of their already admitted status without requisite certainty at the border. Well, it fundamentally violates the default protections Congress intended for green card holders.
So let's ground this in the actual mechanics of the law. The legal architecture here is governed by the Immigration and Nationality Act, specifically Section 1101, subsection A, 13C.
Right, the admission rules.
Exactly. To understand why a pending charge holds so much power now, we have to look at the exact wording Congress used. Normally, a lawful permanent resident, an LPR or green card holder, does not have to reapply for admission when returning from a temporary trip abroad.
Because they are presumed to be already admitted.
Yes, exactly. But the statute lists specific exceptions where an LPR can be regarded as seeking an admission. Exception 5 kicks in if the resident has, quote, committed a crime involving moral turpitude.
Right. And to see how this plays out, we really should look at the case that brought us here, Mukachoila.
Sure, go ahead.
So in 2012, Lau is returning to JFK Airport from a trip to China. When he scans his passport, the border officer's screen lights up because Lau has a pending trademark counterfeiting charge in New Jersey.
This was for allegedly selling hundreds of thousands of dollars in fake goods.
Yeah, it was a major charge. But because of this pending charge, the officer refuses to admit him as a returning resident. Instead, he paroles Lau into the country as an applicant for admission.
Which, to be clear, is what the government argued was the correct procedure.
Right, but the Second Circuit Court of Appeals eventually ruled the border officer was wrong to do that. They said the officer lacked clear and convincing evidence at that exact moment of reentry that Lau actually committed the crime.
Well, Justice Thomas, writing for the majority, completely dismantles the Second Circuit's reasoning. He points out they were imposing a standard found literally nowhere in the text of the INA.
I disagree with the premise that he dismantled it.
Well, he argues the statute creates a necessary two-step process. Step 1 happens at the customs booth. The government only needs a basis to conclude the offense was committed to classify the individual as seeking admission.
But that ignores the default rule.
Let me just finish the 2 steps. Step 2 happens much later, at the removal hearing before an immigration judge. That is where the government must actually prove inadmissibility by clear and convincing evidence. And in Lau's case, the government did exactly that when he subsequently pleaded guilty to the counterfeiting charge.
You're skipping over the fundamental architecture of the statute, though. Justice Jackson's dissent zeroes in on this perfectly. The INA features a clear default rule. It explicitly states an LPR, quote, shall not be regarded as seeking an admission.
Right, unless an exception applies.
Yes, but shall not is not a suggestion. It is a strict, powerful directive from Congress meant to provide ironclad security to green card holders. I mean, they are as close to citizenship as one can get without naturalization.
I agree the protection is strong, but Exception 5 is just as clearly written.
The entire issue here is about sequencing. The government must make a firm, evidence-based determination that an exception applies before demoting an LPR to seeking admission status. The majority essentially ruled that a border agent can just guess.
It's not a guess, it's a pending legal charge.
But they strip away the protections of a green card based on a mere indictment and then justify that massive deprivation of rights with post hoc evidence gathered years later. In Laut's case, they used a guilty plea that didn't even exist when he was standing at JFK.
But demanding a courtroom standard of evidence at the airport ignores the reality of what the word committed means in plain English. The INA specifically uses the word committed. It does not say convicted.
Right, but
Justice Thomas noted this explicitly. He said, one does not commit a conviction. Lau's interpretation effectively requires a border agent to hold a conviction in their hand before acting. That rewrites the statute.
I don't think it rewrites the statute at all.
Help me understand how your standard would actually function in the real world then. If we require clear and convincing evidence at the airport, how does a border officer actually do that while a line of 500 people waits behind them? Are we forcing border officers to blindly wave through individuals who are actively out on bail for severe criminal charges simply because the trial hasn't happened yet?
Look at the grammatical structure of the statute Congress actually wrote. The INA uses the present perfect tense, has committed. This language is written specifically as an instruction for the border officer making the decision at that exact moment in time at the port of entry.
Right.
It is not an instruction for an immigration judge looking back retrospectively years later. The officer has to ask, does the evidence before me right now show this person has committed the crime?
And an indictment for a $300,000 fraud operation isn't evidence?
A formal conviction might not be strictly necessary to hit that mark. Perhaps the officer gets a full confession during the secondary screening interview, or perhaps they make a severe credibility determination based on the physical evidence the traveler is carrying. But there must be some evidentiary standard met at the border.
But
You cannot override the powerful shall not mandate based purely on an unproven allegation in a database. An indictment is just an accusation. It is not clear and convincing evidence that someone has committed anything.
you're demanding an evidentiary standard, clear and convincing evidence that simply does not exist in this specific section of the INA.
It's implied by the gravity of the demotion.
But the statute meticulously assigns burdens of proof in other areas. It tells the applicant for admission they have to prove they're admissible. It tells the government they have to prove an already admitted alien is deportable. But nowhere does Congress say the government must establish by clear and convincing evidence at the border checkpoint that the alien is an applicant for admission. You are essentially asking border agents to conduct a mini-trial at the customs booth.
Asking a border officer to verify they actually have evidence before stripping away a permanent resident's rights is not a mini-trial. It's basic due process. And, we need to dig into why this sequencing matters so much.
Okay, sure.
This isn't just an administrative label on a computer screen. The practical reality of being reclassified as seeking an admission is devastating.
Wait, let's clarify the practical difference here for the listener. If I'm a green card holder returning home and I get paroled in instead of admitted, what actually changes for me the next morning?
Honestly, everything changes. When Lau was paroled in, border officers physically confiscated his I-551. That is his actual permanent green card. In its place, they handed him an I-94 arrival and departure record with a hastily scribbled parole stamp.
Right, the paper receipt.
Think about how the world reacts to that. It's like walking up to the house you've owned for 10 years, but because of a rumor, the guard at the gate changes your deed into a month-to-month lease. You don't lose the house today, but suddenly your entire foundation is precarious.
That's a bit dramatic, isn't it?
It really isn't. Employers are instructed by federal guidelines to treat that paroled I-94 as a temporary receipt valid for only 1 year. Imagine living in the United States for a decade. You own a home, you have a family, you have a career. Suddenly, you are holding a temporary paper receipt that jeopardizes your ability to renew your driver's license, your ability to secure a mortgage, or simply maintain your job.
Well,
You are plunged into a legal limbo that can last for years while you wait for the immigration courts to clear their backlog and schedule your removal hearing.
Framing parole as a punishment misrepresents how the mechanism works under the law, though. Parole governed by INA Section 1182-5-A is essentially a pause button.
A pause button that ruined your life?
In this context, it's actually a benefit. By law, the government has the authority to formally detain applicants for admission at the border. Parole allows the individual to physically enter the country, return to their home, and sleep in their own bed while the legal process plays out. It defers the inspection from the hectic border crossing to a later, structured time in front of an immigration judge.
But the damage is done the moment the card is taken.
And crucially, the heavy burden of proof was fully maintained exactly where it belongs, which is at that removal hearing. The government couldn't just deport Lau based on the indictment. To actually remove him, they had to prove he was inadmissible based on his conviction in New Jersey.
Right.
They submitted his official guilty plea at the hearing. His ultimate due process rights were fully preserved and adjudicated by a judge with all the proper evidentiary rules in place. They weren't decided hastily by a border guard.
That's a fundamental misunderstanding of what just happened to Lau's legal leverage, though. This isn't just a pause button, it's a trapdoor. By letting agents demote LPRs on a whim, the court gives the government a massive blank check to force lawful residents to prove their own innocence.
How are they proving their own innocence?
We have to talk about the mechanics of the burden of proof. When you are admitted as an LPR and the government wants to kick you out, you face deportability proceedings. In deportability proceedings, the government bears the burden of proving by clear and convincing evidence that you should be removed. They have to build the case against you.
Right, that's the standard for deportation.
Exactly. But the moment that border agent hands you that I-94 receipt and demotes you to seeking admission, you are now facing inadmissibility proceedings. Inadmissibility means the law treats you as if you are standing outside the border looking in, asking for permission to cross, even if you physically live in New Jersey.
Because technically, legally, you haven't been readmitted.
Right. And in inadmissibility proceedings, the burden of proof shifts entirely onto the immigrant. You have to prove that you belong here. That is a monumental shift in leverage. You've lost your presumption of innocence purely because a border agent saw an unproven charge on a screen. Isn't this just another example of immigration exceptionalism, where we tolerate the suspension of normal constitutional protections just because we are at the border?
Let's pause on that burden shift because it ties directly into how Congress deliberately designed this system back in 1996. If you look at pre-1997 law, the system operated under something called the Fleuti Doctrine.
Yes.
Basically, if an LPR took a brief, casual, and innocent trip abroad, say a weekend in Canada, the court said they weren't making a new entry upon return. But Congress looked at that system and decided it was too lenient. In 1996, they passed the Illegal Immigration Reform and Immigrant Responsibility Act.
IIRI.
Yes, IIRIA. They deliberately replaced the vague concept of entry with a strict definition of admission. And they explicitly wrote Section 1101A13C to outline exactly when an LPR is stripped of that status and treated as seeking admission.
Sure, they updated the law.
The majority is simply honoring that deliberate congressional shift. Congress wanted border agents to have the flexibility to flag individuals involved in serious crimes, like a $300,000 counterfeiting operation, before they disappear back into the interior of the country.
But Congress also wrote the words, shall not. If they wanted border agents to have unchecked flexibility, they wouldn't have created a rigid default rule protecting green card holders. Justice Barrett, who joined the majority, frequently champions textualism, yet here the court blatantly ignores the grammatical reality of the statute to achieve a policy outcome favoring the government.
The grammatical reality of committed versus convicted?
It's a textbook example of immigration exceptionalism. The courts tolerate the suspension of normal constitutional protections simply because the interaction happens near a physical borderline.
While border checkpoints are fundamentally different environments than interior courtrooms, and the law reflects that. Border agents have access to vast international, federal, and state law enforcement databases for a reason. They are entrusted to make quick judgments on the spot to protect the nation's ports of entry. Congress did not intend to turn the customs line into a courtroom.
But the consequences are so severe.
And we must look at the actual scope of this ruling, rather than catastrophizing. The court's decision is constrained strictly to the evidentiary standard at the border for this specific criminal offense exception.
Okay.
It does not rewrite the substantive grounds of inadmissibility. It does not mean border agents can just randomly revoke the green cards of people with clean records. The general rule remains completely intact. LPRs returning from brief trips abroad are safely presumed admitted. The only people affected by this specific ruling are those who have entangled themselves in the criminal justice system.
Entangled is doing a massive amount of heavy lifting in that sentence. Let's look at who actually gets caught in this net. What about an LPR who was arrested but later fully acquitted of all charges? What about an LPR with a minor, decades-old misdemeanor that a border agent suddenly decides might be a crime involving moral turpitude?
They would hash that out in court.
But because the border agent no longer needs clear and convincing evidence, they can over-apply this to motion right then and there. They can confiscate the green card of the acquitted person. They can seize the card of the person with the old misdemeanor. They can shift the burden of proof onto them and trap them in an immigration court backlog for 5 years.
Look, the legal framework requires us to—
Wait, if they are truly innocent, yes, they might eventually win in front of a judge. But the punishment is the process, the legal fees, the loss of employment, the sheer terror of facing inadmissibility proceedings. The Supreme Court just handed the executive branch a weapon to wield against lawful permanent residents with zero upfront accountability.
The legal framework requires us to separate the procedural mechanism from the ultimate substantive judgment. The procedural mechanism, the parole at the border, is the intake valve. It allows the system to process flags in the database without building massive detention camps at our airports.
Intake valve is a very sterile way to put it.
If Congress wanted border agents to wait for a final conviction before touching that intake valve, they would have written "has been convicted of," just like they did in dozens of other places throughout the INA. They wrote "committed." Requiring a conviction at the border rewrites the statute from the bench.
But we haven't even resolved the most glaring ambiguity in this entire scenario. What actually constitutes a crime involving moral turpitude, or CIMT? It is one of the most notoriously vague, undefined concepts in all of immigration law.
It is definitely complex.
Generally, courts say it involves an inherent intent to defraud or cause bodily harm. But the definition shifts constantly depending on the state and the specific statute. And the Supreme Court purposely didn't even decide if Lao's trademark counterfeiting actually qualified as a CIMT.
Right, they remanded it.
Exactly. They punted on the core question and remanded the case back to the Second Circuit for that determination. So think about what happened here. A border agent made a life-altering classification, confiscating a green card based on a pending charge for an offense that might not even legally trigger the exception in the first place.
I see your point.
That perfectly illustrates the danger of removing the evidentiary standard at the border. You are letting officers make wild guesses on incredibly complex statutory definitions.
The remand actually proves the system operates exactly as it should, though. It separates the roles appropriately. The border agent flagged a serious $300,000 counterfeiting indictment. They didn't deport him. They paroled Lao in. Then the judicial branch evaluated it
Years later.
The Supreme Court clarified the exact evidentiary standard required for that initial border encounter, but they respected the judicial process enough to let the lower appellate courts finalize the complex substantive definition of the crime itself. That is not a wild guess. That is a measured, appropriate application of administrative and judicial resources.
We just fundamentally disagree on the acceptable level of collateral damage here.
Well, to summarize my position in light of our discussion, the decision in Blanch v. Law respects the strict text of the Immigration and Nationality Act. It recognizes that committing a crime is what triggers the exception, not possessing a formal conviction paper at the airport. By doing so, it properly leaves the heavy, complex burden of proof to the immigration courts, where evidence can be properly weighed and cross-examined, rather than demanding border checkpoints function as criminal courts.
And my summary is that this decision effectively guts the statutory protections Congress painstakingly built for lawful permanent residents. By removing the requirement for clear and convincing evidence at the border, the court allows the government to strip away the foundational security of a green card based on unproven allegations. It plunges returning residents into years of legal and economic limbo and quietly shifts the burden of proof onto the immigrant to fix the government's paperwork years later.
Regardless of our fundamental disagreement on the jurisprudence and statutory interpretation, we clearly converge on the practical reality for listeners. This ruling dramatically increases the risk of international travel for any green card holder with a criminal record.
Absolutely. Whether it's an old misdemeanor, a pending charge, or an arrest you thought was completely resolved, the threshold for being pulled into the inadmissibility track at the airport is now significantly lower. The shield of the green card is no longer what we thought it was.
And the definition of a crime involving moral turpitude remains a highly complex area of the material, really ripe for further exploration. As always, we leave it to you, the listener, to form your own conclusion about the balance between border security and due process. Yesterday, the Supreme Court ruled that border officers can strip away a returning resident's presumed admission status based on pending charges alone. Does this honor the precise text of the law, or does it hand the government a massive override switch?
It's definitely something to think about.
Thank you for joining us on The Debate. Please take a moment to like, subscribe, share, follow, and turn on notifications.